Hi, this video is going to discuss whether you can make or have the court order the other party to pay for your attorney's fees in family court. I'm Allysyn Overton. I am a family law attorney here in the San Francisco Bay Area. And I just want to let you know as a disclaimer that this video is for informational purposes only and does not constitute legal advice, and nor does it constitute an attorney-client relationship. The short answer is yes, and the more complicated answer is it depends. So, can I make my spouse pay for my divorce attorney? The law currently is that if the other party can afford to pay both yours and his or her own lawyer, then yes, you can request from the court that, and you have a likelihood that the other party will have to pay for your attorney, at least initially. Now, this really turns on the idea that both parties deserve to have representation for them during the family law proceedings. So if you have a bunch of cash, because I should say that the other element to that is you have to prove that you can't afford an attorney either. So the other party has to be able to afford his or her own attorney and yours, and you cannot afford your own attorney. So if you ask for fees and yet the other party can show that you have $100,000 in cash in your bank account, then you might not win on the attorney's fees request, because the court sees that, well, you can afford your own attorney. You have this $100,000 in cash. You can use some of that to hire an attorney. However, let's say that you are, that the other party handled all of the expenses and all of the financials of the family while you were married, and you don't even know what bank the community property is in, and you don't have access, then yeah, the court would likely grant your request. Now, that being said, when it comes down to separating the assets, the court can also take some of your community property away from you to reimburse the other party for the attorney's fees that he or she paid on your behalf. I haven't seen that happen a lot, but it is quite possible, because remember, at the end of the day, it's not about punishing. It's not about saying like, well, it's your fault that they're getting a divorce, so I'm going to make you pay for the attorney's fees. It's not about that at all. The main idea is just making sure that both parties have a lawyer. So if the court can make orders that are going to, that's fair in its eyes, it's going to do that. And if that means that the party that's paying the attorney's fees gets reimbursed for those out of the community property, then that's what's going to happen. The court can also order that your attorney's fees be paid from the community property. Let's say that there is that chunk of cash sitting in a community property fund. The judge can make an order that your community property award is basically you're given an advance of that from the community property fund. And so you're actually borrowing against your own future community property interest. I hope that that's clear. Again, the short answer is yes, you can request that the other party pays for your attorney's fees, so long as you cannot afford to pay your own attorney's fees and you can show that the other party can afford both his or her own attorney's fees and your attorney's fees. And then there are all of these different details to that answer as well. So if you have any further questions, please feel free to leave those in the comment section. I'll do my best to answer general questions as I can. If you'd like to set up a free consultation, please feel free to give me a call. I will leave my number in the description box below. I wish you all the best in your family law endeavors. Thanks for watching and have a great day.